It is my honor to welcome Mahdi Bagh Youth Club's President Mr. Moin Malak, Vice President Mr. Noor Malak, Secretary Mr. Farooq Haq, the GB members, heads and vice heads of all the committees. Mahdi Bagh Youth Club was founded 10 years ago by our Honorable President Mr. Moin Malak, where he drives a group of talented and dedicated people with the sole aim of giving back to the society. MBYC keeps conducting various informative sessions on varied topics and is actively involved in philanthropic activities. We have grown from Nagpur and reached out to Vishakapatnam, Hyderabad, Pune, Bangalore, Ujjain and Indore. We also have international branches in America, England, U.A.E, Singapore and Australia. Our mission Mahdi Bagh Youth Club is first to conserve and promote art culture, secondly to work for the social well-being of all communities around us, and also to organize events, art shows and philanthropic activities on a larger scale for the purpose of creating awareness and supporting social causes. Lastly, to build a strong foundation for the youth so as to represent India to the world. Introducing our resource person for the day, Advocate Zehra Anwar is an advocate and legal professional practicing at Hyderabad. She has an overall experience of 20 plus years in the field of estate planning, property due diligence, and other civil, criminal, and consumer disputes. She has handled matters related to corporate and constitutional laws. Along with holding a bachelor's degree in law, she has also pursued a master's degree in intellectual property laws and postgraduate diploma, cyber laws, and psychological counseling. She is titled with various professional associations. To name a few key associations, she is Best Social Worker in the field of law, Telangana President of National Human Rights for Women and Children Welfare Commission, Council Member of Women Indian Chamber of Commerce and Industry, External Posh Member of Education, Next Education, and the founder of ZR Legal Services. Without further ado, now I'd like to invite Ms. Zehra Anwar to address the inquisitive minds present in the session today.
Good morning, everyone who all are attending this webinar today. Good evening, everyone who all are attending this webinar today, and also the live audience on the Facebook. First of all, I take this opportunity to thank the MBYC President, Mr. Moin Malak, and the complete team of MBYC Skills and Entrepreneurship for inviting me to conduct this webinar on estate planning and wills. It is not only an honor, but a privilege to be a member of such an organization, Mahdi Bagh Youth Club, which is working towards society development and youth building. This webinar is this session is conducted on the topic as Najib has already introduced. And thank you, Najib, for introducing me in such a wonderful manner. Estate planning and wills. Building on the belief that everyone needs estate planning. Planning is an important aspect of our life. Since our birth, we need planning. Planning in all aspects of life. Planning in education, planning, financial planning, educational planning, career planning. For job, we need a planning. For higher studies, we need a planning. The area which is most needed in planning and which has been ignored by one and all, in which this webinar has been conducted, is estate planning. Now, estate planning, the term is little new to the Indian individuals, Indian citizens, because we always talk about wills, trusts. Estate planning is a smoother way of transmission of your assets which you have acquired and accumulated throughout your life. Now, this session will be presented in an audiovisual manner. We will be sharing a screen with a PPT, which will help you understand more about what is estate planning, how important it is, how necessary it is to have a proper estate planning, either through wills or trust, and what are the myths in the connection with this, that because of which we are not able to do the estate planning. Just a minute, I will just share the screen. Now, first is, what is estate planning? We know about planning, financial plannings and all, in which we plan our insurances, mutual funds and everything. Now, what has to be planned under estate planning? As you can read it also, estate planning in simple terms refers to the passing of an assets. These assets which we have acquired and which have accumulated throughout our life, the wealth which we have acquired. Actually, when this term comes into the picture, we related that it is post our demise, which will come into the picture, but it is a transmission. It is a smooth transmission of our accumulated and acquired assets to our loved ones, so that they will also enjoy what we have acquired through hard work and built up on that asset. It is not just that we need, this has to be done and it will come into the picture after our death, so it is not important. This negative thought which has come to us, we have always been ignoring, due to which we are not able to do a proper estate planning and our transmission of assets are not being done properly. And due to which our children and our loved ones and whom we wish to bequeath our properties suffer a lot of legal hassles. The dispute arises, and all that assets which we had acquired through such a hard work and we wanted to enjoy and let it be enjoyed by generations together, gets into the legal troubles. And it goes into the legal battle for long period of time. Yet you can say it is a dynamic process that needs to be reviewed at regular intervals to absorb any changes that might happen in our life or in the laws of the country. Like, you can read myths and facts about estate planning. This is very important here, because what we always think about estate planning is that it is for the wealthy. The rich should do the estate planning because we don't have anything to do it. But here I will just share one fact, that even Michael Jackson had not planned his will. He had no estate plan done. But later on it came to know that he had planned it, but by that time his wife and children had already approached the court and they had spent lots of energy and time and money to get it administered in their name. So it is not that only the wealthy need estate planning. Estate planning is need of the hour for every individual who has the assets. Assets can be what, movable, immovable, whatever assets you have. It may be small in amount. It may be bank balances, some sort of a property, jewelry, car. That is your estate. It can be bequeathed or transmitted through will or through a proper, on a broader scale. If it has more of an assets you have, it can be done on other ways also, which are wills and trust, which we will go into in the later slides. Now, the second myth which we have is estate planning should be thought of only after retirement. We think, no, we don't need an estate plan. We are in the working part. We are still young. We are enterprising. We are accumulating. Why we should think of anything? We don't have to do anything. Why should we think about transmission at this stage? Let's enjoy. But in that process, we never enjoy. Actually, our process of acquiring only goes on till our retirement. And if any untoward incidents happens, then that thing which had to be transmitted at an earlier stage, that thought which had come earlier, we don't just do it and we pass it on to a later stage. And if it is not done, then as everyone knows, it goes into the government, or it will be just interstate, and then the fate will be decided accordingly as per the laws. The third myth about is, my legal heirs will handle it maturely. We think that after our death, our children or our generations, whoever is left behind, will take care of that property which we have. But unfortunately, it is not the exact thought which we should have. It is not like that. They might have disputes. They might say, this is mine, this is mine. that process of disputes will go on, and that particular property will lie just like that in a dilapidated situations. The next myth is, I have registered my nominees. They will anyways be the beneficiaries of my assets. Now, there are insurance policies, mutual funds, and other things wherein there is a column for nominees. Now, who are nominees? We say, I have already got a nominee, I don't need a will. But what are nominees? The owner of the asset, the nominee may not always be the owner of the asset. The owner of the asset will be the legal heir as per the will, and in the absence of a will, transmission of assets happens as per the country succession laws. So it may be possible that the legal heir is a nominee, but in some situation, if a nominee is not a legal heir, then the benefits, the profits out of that particular property or asset will not be able to pass to the legal heirs or the legal beneficiaries. So again, that myth is that I have a nominee and I don't need a will is absolutely wrong. You need a will so that your things pass on to your wished and whom you want, that desired nominees or the desired beneficiaries. I don't need a seek legal opinion. Now, okay, this is a myth and a fact both, because there is nothing wrong in seeking a legal opinion. Like a doctor is an expert in his, a lawyer can guide you to ensure the estate planning is done legitimately, considering the nitty-gritties involved. Now, what are the nitty-gritties involved? I'll just give you one example. Recently, I came across a will of a client. He had drafted it, and his wife had come to me with the will, say that it is becoming very difficult for me to transmit all these properties in my name or whoever is being mentioned in the will. Looking to that will, on the first reading, it was mentioned, I have some litigation properties which I would like to bequeath to my wife and my 2 children equally and build an old age home over it. Now, reading this paragraph, it really became very difficult for me how it is litigation property. When a property is in the litigation, it is not actually his property. So how can he bequeath his property? He has to be an owner of that property to bequeath a property. So here again, because he was a layman, he just drafted a will as what he wanted to write. In another paragraph, he writes, I bequeath this house to my 2 sons in equal shares. But right to stay of my wife will be there till she is alive. And till that period, there should be no sale and possession will be with my wife. Now, again, these terminologies will be a difficulty for us to go under the how to execute the will. So here comes the role of a legal expert to let you know what should be the wordings when you are drafting a will. Now, importance of planning. Why it is important? What is that it makes it important? If distribution of property and estate is governed by as per laws of all the nations. In India, there are 3 more personal laws which governs our transmission of property or wills and estate planning. If you are a Hindu, it is as per Hindu Succession Act. Christian, Jews and Parsis as per the Succession Act 1925. And the Muslim property as per the personal law. That means, again, this means that our loved ones might be left with the out of disposition of the property if they don't know which law we are governed by. So therefore, estate planning is very much required, as this untimely planning for your own assets with the future perspective in mind. Now, here also one more very good example of my own client. I would just reiterate here. He's a colonel who stays in my neighborhood. He approached me during pandemic to just assist him in drafting a will. He called me and said, I am living singly. My children are both citizens of they're foreign nationals. They are not interested to come to India and they don't want any assets from me. But it's my will and wish to give it to my children. So I would like to draft a will and you assist me in drafting the will. We drafted a will. Fortunately, he wanted to register it also, and we did a registration also. After a period of 6 months or so, I wasn't able to see him going by my place, as he used to usually come for a yoga or some activity. Then one day I just called him to inquire how he is doing, what's happened, why he's not to be seen. He did not attend my call. The neighbor of him just informed me that sir had a attack and sir is incapacitated. Sir has even fallen down due to the attack, and he's been dislocated his all right side and is not in a condition to reciprocate. And that time when I was with him, he had told me that I feel this is important to do at this stage. I don't know what happens. So such incidences are so common with us. And with COVID-19, which has not yet passed out of our faces, it has showed that how incapacitated it had made an individual. It had incapacitated us financially, physically, mentally. We were brain out. People were brain drained, not understanding what to do. There were clients who were coming to us stating that our loved ones have passed away. We don't know what to do with these assets. How do we go about? Banks are asking for succession certificates and the legal heir certificates, because unless without that, we cannot inherit this property. And the nitty-gritties involved in getting a succession certificate or a legal heir certificate are, as you know, are very lengthy and very time consuming. But they had to go through it. One more example of a similar nature I would give. This is also for my client who is an NRI. And they happened to lose their mother in 2020, and they happened to come in 21. He might have also joined this session. I'll not take his name, but I'll just, what happened with them. They had a locker in the bank, and in the locker, everything was there inside. Now, when they came here and they wanted to get access to the locker, they were not allowed. They were being told that unless you give us a will or a succession certificate, you cannot take access to the locker. It is since 2022, they are not able to take the access to the locker. And everything what mother had regarding the property and all the originals are in that locker. So these are the situations which land up when we are not have a proper plan or a proper will, wherein we are naming our loved ones who can properly inherit that particular asset which we have already got. Now coming to these methods of estate planning. It is not only the wills that we know about estate planning. Will is one mode, one tool we can say, which helps us in estate planning. When we have a lesser estate with us, it's a single document. It doesn't, when writing a will, it doesn't have much to do. It is not needed to register. You can just write 2 lines and it will be a will. In India, absolute no registration is required. And all over the world also, it is not mandatory to register a will. If you want, you should register a will. Otherwise, even a white paper, wherein your intentions are being clear, to whom you want to bequeath this property, transmit this property, the manner it should be done, movable, immovable, whatever assets you have, is what is the requirement. So it's a legal declaration of the intention by the one making it, the testator with respect to property that desires to be clarity to effect. Clarity on who gets assets, what and how much, exclude estranged people. Authenticating a will by the court known as probate. Now probate is not there in India right now, it's not a
Ma'am, you'll have to unmute yourself.
Yeah.
Now, methods of estate planning, when we said wills, now it is come to trust also. So this is a very nice mode of transmission of your property. When we hear of a trust, we only have, there are religious trusts, there are spiritual trusts. No, but there is one more category of trust that's called a living trust. Now, what is a living trust? Or we say there is a private family trust which we can make. In a living trust, you can even, it is a revocable and irrevocable of both nature. Revocable, it is in the lifetime, you entrust all your properties to the trust and the beneficiaries are enjoying the benefits of it. You are the trustee, you are the settler. You can be a trustee and a settler, you can be a settler and a beneficiary, and you can even enjoy what you have already put under trust. It's an excellent way, though it is, it has tax aspects to it, it is a little bit costlier than a will. But as we have that thought that it is a will, only after our demise, the property will be transmitted or it should be enjoyed. In the trust, that aspect is absolutely ruled out. You can enjoy what you have already earned in this manner. The key features of a trust can be used to achieve a variety of specific goals. It has 6 broad categories: living, testamentary, funded, unfunded, revocable, and irrevocable. Now, when we say revocable trust, means till you are alive, you can add and subtract from that trust. That's a wonderful part. And even a living trust, you can give directions for how, if you are incapacitated or you have been put under terminally ill condition tomorrow, who will take decisions regarding your medical bills, who will, as in the COVID times, we have come to know many had been landed into ICU with nobody to look after, or how to pay off their bills, what were the resources to do that. So under this, you can even give a direction to the trustee or a person, professional person, that how it has to be managed. Trusts are frequently used in estate planning to benefit and provide for the distribution of assets to the heirs of the grantor. Now, when we say about what is more effective, wills or the trust, exactly, there is no thin line between that. It is your choice, absolutely. How much assets you have, how much the way you want to transmit or transmission has to be done, how you desire to do it. Either it can be through a will, it can be through a trust. Living trust, as I said, created during truster's lifetime. It's transferred to the beneficiary trustee. You can have both. Some properties you can hold it in trust, and some properties you can even bequeath through wills. So more effective if we say it is trust, because it is in your lifetime you enjoy your assets. Wills, it is always, as you know, it is after a demise of a person, it comes into being. Trust is a, as you say, it's a living trust. It is operative in your lifetime itself. One can choose, as I said, one can choose both wills and trust in estate planning. Wills and trust are not to be seen as competing against one another. It is an either case, rather it depends on what works best for your estate. However, too many sometimes work together. For instance, trouble may arise in the trust without a will when the asset outside the trust becomes subject. This has been already covered when I said you can have both together, a trust and a will, where in whatever is not being included in the trust, you are free to, and you have the right, you can do it in a will. Now, what are the benefits of estate planning? First, prevents financial and legal grief of your loved ones. That as we have been taking the, I've been explaining this, and we have spoken about this in our importance of estate planning also, why it is important. The benefit also flows from that only, that financial and legal grief means when, if there is no will, in the case of an intestate will, somebody dies without a will, what happens to their property? How a legal heir, how a beneficiary can inherit that property? Now, either it will be through the personal laws or the Indian Succession Act, and if nothing is possible, then it will go into the hands of the government and they will take appropriate action how it has to be bequeathed. So just to avoid all these things, it is very important that we should have a proper planning and we should have a proper will towards bequeathing our property to our loved ones as we will and wish. Avoids complications, disagreement, bitterness, and drift in the family. This is a very common thing which happens in case there is no will. In fact, sometimes it happens when there is a will also, but that is very much nullified. But when there is no will, there are chances that this might arise. If we take an example, if someone person is his whole life he is earning, he is a big businessman and he has done so many ventures, and some of the ventures fail and they have taken so much of loans, and one or the other loans, they are just covering up their other ventures. Finally, something goes wrong and that is not working, and they go into the financial burden. About this, children are unaware what has happened actually. And suddenly, due to all these stress and trauma and depression, the person expires. He has not planned anything. Children are taken by surprise. They land up in seeing how much of loans and burdens, financial burdens the person is having. They were only enjoying their life at the time what the person was earning. Now what to do? There might be that the children may say nobody is ready to take the burden. Now what happens in that situation? That whatever has been already left goes to the bank or whoever has been mortgaged with. So that property which your father or whoever our the inheritance goes into the hands of the government. You are not able to enjoy what your father had all through his life, put a hard work to get it. Ensure that physical, financial, and online assets are passed on to your loved ones. Now, here I mean assets. Assets are not only movable and immovable properties, it is a liquidated assets also. Online assets, I mean by when there is an intellectual property, a trademark, a patent, all these also are your assets, which can be passed through will. A goodwill of a business, you can pass through a will. So it is not only that when we come to know about, talk about will, or we discuss about wills and estate planning, we say, I don't have a house, I don't have any fortune, what I should pass on. Maybe you have some a skill set which you want to pass on. You might have an online asset in the nature of, as I said, a trademark or a business name or a patent, something which you want to pass on. That also is a part of your estate. Can provide for or address to a family member or a loved with a special needs. In the will, you can write there might be a person who may, a girl who is not married, she may have some disabilities, he may have some disabilities. You want particular part of your assets to go to that person rather than who has been legitimate and all good enough in their capacities. Estate planning can also help pass accolades bestowed on you to a specific individual. That's also that just now I have mentioned that goodwill of a business can be passed on. Your patent, your trademark, anything of that nature which you have acquired can be passed on through the will. Helps the beneficiary reduce tax ago on account of inheritance. Now, did you know? These are some of the very unknown facts which I have got it for you to know how Indian Succession Act has came into the being. This is a very interesting thing that when I was just reading about this topic, I came across it. Indian Succession Act 1925 came into force after the major pandemic in 1918 and 1919. That was a Spanish flu. So that bigger pandemic gave way to this act, which is 96 years old, Succession Act 1925. Now, after this pandemic, what has happened? After the first pandemic, which we had 100 years old, 1918, 1919, Spanish flu, Indian Succession Act came into the force. Now, after this pandemic, what are the changes brought about in the estate planning and majorly with regard to the signing of the will or as part of the witnesses to the will? In the USA, a US court held that a will drafted on a tablet and signed by a testator under the supervision of 2 witnesses, then the will shall be held valid. Given the judgment, the Uniform Law Commission of USA drafted a Unified Electronics Wills Act as model act be adopted by the US state. During the COVID pandemic, many US states issued emergency orders regarding remote witnessing as well as notarization of will in order to execute wills. Even now, the digitization of wills, the digital signature with regard to wills are in the discussion, even with the Indian Planning Commission. In the United Kingdom, the execution of wills can be done via video conferencing with the witnesses. This provision came into force on January 31. On January 31st, 2020, due to the rise in the number of active COVID cases in the UK. The same provision was enforced by the Law Society of Scotland for a temporary period. Now let's see what Ontario government allowed witnesses. They allowed witnesses of wills on 2 conditions: that the participants should use an electronic medium in order to communicate with each other, and among all the witnesses, at least one of them should be a lawyer. Usually whenever we draft a will and all, they say that a witness should not be a lawyer. But this, they particularly and specifically stated that a lawyer should be a witness to the will who has drafted the will. This is a very important aspect which this government has addressed to. Now, this is a will pro forma sample which we have prepared just to make you understand how it looks and what all is required for the will. How it should be, you can just enlist your properties and enlist everything. This is a pro forma document which you can go through later on also. If you want, I'll just say some of the important points in it. Like you have to just put up your who you are and your details, then whom you are appointing an executor, whom your family consists of, your spouse, your children. Then you have to list down your property consists of, what all the properties you have acquired or accumulated, maybe an ancestral property also. And then whom you want to bequeath and what are the parts in what manner you want to do it. Now we have come to the last slide of our presentation. Before we are going to this, when I started, I said, building on the belief that everyone needs an estate plan. I would just quote unquote Joseph Murphy. He once said, law of life is the law of belief. It is not the thing you believe in that brings about the result. It is the belief in your mind that brings about the result. So to conclude, I would say that not only as we said that it is the rich who needs a will, and we don't need a will. It is a belief that we have just put it in ourselves that we don't need a will, we don't need a estate planning. It is often difficult to discuss matters of death and inheritance. However, in times of crisis, it is often best to be prepared. Documenting wills can provide some certainty and confidence to both testators and family that their family matters will be taken care. Wills can help provide security for family members and testators even in the times of crisis. When I was giving you examples that there are cases of the rich also who have not drafted their will, I would give some more example for you to understand that what happens when it is not been done. You have heard about Pablo Picasso. He died in 1973, leaving behind a fortune in asset that included his artwork, 5 homes, cash, gold, and bond. Because Picasso died intestate and left no will, it took 6 years to settle his estate at a cost of $30 million. His assets were eventually divided among his 6 heirs. Another very famous personality I would let you know is Abraham Lincoln, the 16th president of United States and the first to be assassinated, as well as the first president to die without a will. And he was a lawyer. Despite being a lawyer, he never made a will. Recently, Black Panther star Chadwick Boseman, 43, passed away in August 2020. He didn't have a will and had an estimated fortune of $938.500 million. Estate that's subject to probate in the court now. So famous or not, everyone should have a will. It's simple to do and it saves your family a lot of money and headaches. And as illustrated by the stories above and the examples we have discussed today in this session, you are never too young or too smart or too powerful to have a will. Ensure your loved ones and property are protected. Thank you. For any assistance in will drafting or advice, you can contact me. These are my details here. We'll share, Najib will also share in the chat box. Najib, for any questionnaire, please.
Yes. Firstly, I'd like to thank you very much, Ms. Zehra, for this insightful session. Surely there's a need for everyone to have an efficient estate planning, irrespective of their age. We surely gained a wonderful insight on today's topic, and I'm confident that it has helped everyone present here immensely. I have received a question in the chat box, which is that ma'am has said that registration of will is not compulsory. However, we have experienced that a will on paper is not accepted anywhere. It has to be registered. So could you please clarify on this?
No, exactly. As per the Indian law, it is not mandatory for registering a will. There are courts and there are authorities which demand a will to be registered. But as per the law, it is not necessary.
Okay, thank you. And if anyone has any more questions, you can unmute yourself and ask directly or post them in the chat box. And in the meanwhile, I'd request Ms. Arifa Banglowala to give a certificate of appreciation to our session expert for today.
Thank you so much, Najib. But before I go on with this appreciation for our session expert. We have a few more questions. I would rather like them to be answered first. So
Sure,
let us
yeah.
take them. Yeah.
Zara ma'am, would you take them or should I dictate
Yes,
them
yes,
to
yes.
you?
I can read this. Shanur has asked a question. What is the difference between a nominee and a heir? Nominee is whom you nominate when you are filing anything. He can be your heir also or a non-heir also. It is not a compulsion that should be a nominee, should be your legal heir only. Your legal heir are your children, your parents, and your husband, if you are a married person. So that is a difference between a nominee and a heir. The another question is from Mr. Moez Manan. What is the difference between a will and a letter of succession? It is another terminology used towards succeeding your inheritance. In other terms, we say will is a letter of succession also.
Okay, I think these are all the
Anyone
questions.
else who wishes to ask?
Yeah.
You can feel free to unmute yourself and talk.
Yeah, this is Shafiq. Thank you, Zara ma'am, for this wonderful session. Are you hearing me?
Yes, yes, very much.
Yeah.
Thank you.
So
Welcome.
my question here is, when we talk about estate or will or trust, we always discuss about the asset part, which a person has accumulated and which he would like to give to a nominated person or heir in a very written and documented form, that it does not have any future litigations or discrepancies to cash it on.
Right.
Now, my question is, we talk always about the asset, but nowadays they also have let's say liabilities with them. You have clearly explained that point. I got it, that the banks or other people, the government missionaries, they will settle against those assets and the remaining portion will come. But in the event that the liability is more than the assets, does the person who is inheriting those the will or the assets, will he have to clear those liabilities legally, or or only the asset part he will get it? Did you get my question?
Yeah, I understood. You are telling that if the assets which already are there with the bank are not enough to fulfill the loan or any liability which the person who has demised has already been on his head, right?
Yes.
So what happens in that event? Are the other properties for which the legal heirs are inheriting, do they have to give away the amount and do the balance part from the property which are not being included with the bank?
Yes.
That depends on the business loan, business part of the aspect of this a particular situation, wherein what type of property has been mortgaged. Is it the business which has been mortgaged and then a loan has been taken, or the liability has been bundling up due to multiple assets being mortgaged by the bank and whatever is left behind? So that is up to the situation, how that liabilities will be shared by the legal heirs. But to some extent, they have to fulfill the liabilities of the person who has demised.
So yeah, so then it becomes an additional responsibility to the person who receives that
Yes.
will. Yeah.
Yes.
Okay. So I mean, I know it's a bit tricky, but this also needs to be tackled.
This also
at
can
that
be
time of-
addressed in the will, how the liability should
Exactly.
be taken care of by the
Exactly.
legal heirs or the beneficiaries whom this property is being bequeathed.
Yeah, because they should not receive a surprise thinking of assets they are getting liabilities. So
Yes.
that needs to be addressed also while drafting. I guess so. So thank you very much.
Welcome. The law has a beneficial legislation also. When it is punitive and reformative, it has a beneficial part also, which, like when we say that we have to be preventive measures when we take, it is sort of like that. If we are already prepared and planned, these issues which you were talking earlier with me don't arise at all.
True. We need to gather that courage, and with able guidance from, advocates like you, we can definitely come over that fear of getting into these legal nitty-gritties, the word that you use. And of course, the session was definitely very, very insightful. We being a part of this pandemic where we saw some of the most devastating things happening in our lives, losing our dear ones, we are the ones who should be, very, very aware of all these aspects of law. And will and estate planning is something which is very, very important. Here, I would like to take the opportunity to once again express my gratitude and hand over a certificate of appreciation for the expert of the session today, Advocate Zehra Anwar. Thank you so much, ma'am, for coming up here and talking about the legal aspects of will and estate planning. Thank you so much. I would also like to thank each one of you for joining, and I would like to tell you that we keep doing such sessions from time to time. We will keep you updated. I'm sure Najib will be sharing a Google form with all of you. Please do fill in your feedbacks there, and we will keep informing you for our upcoming sessions. Let me tell you, we have planned a wonderful session on emotional intelligence, something once again, which is a very, very important part of our lives now when we are working in corporates or when we are dealing with people. So we are going to have that very soon, and we'll inform you about it. Thank you so much. Over to you, Najib.
Thank you, Arifa, and thank you, Mahdi Bagh Youth Club, for giving me such opportunity to be on this panel and conduct this webinar. Thank you for the certificate of appreciation, and thank you one and all.
Yes, thank you very much, Ms. Zehra. So Mahdi Bagh Youth Club conducts such workshops and masterclasses on a regular basis, and we also have a YouTube channel where you can catch up on previous workshops. The link in the chat section is for you to check it out, and don't forget to hit subscribe. You can also follow us on Instagram at MB Youth Club for more updates. Now, with the constant support of MBYC's president, Mr. Moin Malak, we hope to have many such informative sessions in the future. Happy weekend.